was no new fact. And if there is a new fact, that means the bail application should have proceeded, and therefore we say that the learned magistrate material misdirected himself.
Wait, now I'm confused.
Yes.
Bail application should have proceeded.
Yeah,
wouldn't it have been then the bail application should have succeeded?
Should have succeeded, Malini.
Not proceeded, because we're already proceeding in the bail application.
Indeed so, Malini. Indeed so, Malini. But all I'm saying is, perhaps, let me try and put it differently, is at the magistrate's court, at the court of quo, if the court found that there are new facts, then the court should have moved to the next inquiry, which is whether there are exceptional circumstances. But the life of the bail application was cut short before it went there. And I'm saying the finding that there is no new fact sort of prematurely ended the inquiry. And it is material. It's a material misdirection on the part of the learned magistrate.
But let me ask.
Yes, Maria.
At the bail application on new facts, at that stage, all the evidence was placed before the court. So it wasn't a scenario of if we would deal with a civil, and I'm giving it as a very basic example, but in a civil inquiry, if you're dealing with an urgent application, you focus only on urgency. If urgency succeeds, you proceed then on to the merits. Insofar as the bail application itself was concerned, it was a bail application on new facts. Everybody testified that needed to testify. All the evidence was placed before the court that was needed to be placed before the court. And then the court made its finding. Whether its finding, and this is where you differ, being the appellant, from the court a quo, in the sense that the finding was there was no new facts. What the court is, this court is trying to ascertain from the appellant, counsel for the appellant, would it not have been then already ventilated so we would not go back to an inquiry as to exceptional circumstances on this new fact? Do you understand what I'm asking?
I understand, but I view it differently, if I may, please.
Please help me see your view that's so different.
My lady, my understanding of a bail application on new facts, not on appeal because the test is different.
Obviously.
There, the court has to satisfy itself firstly that there are new facts. And if the court finds that there are no new facts, then the inquiry ends. But if the court finds that there are indeed new facts, then the next inquiry that has to be made, my lady, is with respect whether there are exceptional, because this is a Schedule 6 bail inquiry, whether there are exceptional circumstances which in the interest of justice permit the release of the appellant. And what we are saying is that the finding on the part of the learned magistrate that there are no new facts ended the inquiry. The bail applicant was refused bail on the finding that there is no new fact. And I'm submitting that if there is a new fact, then the learned magistrate materially misdirected himself because he ended the inquiry too soon and wrongly. Thanks, Malini.
Just on this point, are you then saying, am I hearing you correctly, there is a two-pronged process that's supposed to have taken place on this bail application on new facts?
That's correct, Malini.
And procedurally, how would this take place?
What happens, my lady, is we leave evidence. But the first inquiry, or the first determination that has to be made, is whether there is a new fact. If there is a new fact, he doesn't get bail. Then we move to the next inquiry. The next inquiry is whether there are exceptional circumstances which in the interest of justice permit the release of the appellant, the applicant at that point. If the learned magistrate finds that there are no new facts, he does not move on to the next inquiry. But on appeal, it's a bit different. If we find, and this is my submission, if we find that there is a new fact, then we are saying that the learned magistrate materially misdirected himself because he refused bail on the finding, which is wrong, that there was no new fact. And the finding itself is wrong because then the inquiry should have went on there. But here, the test is whether it was wrong or not. If it's found to be wrong materially, then the appellant should succeed. That's our approach, and we submit that it is the correct approach, my lady. Yes. My lady, there are a number of new facts which we have submitted. And may I say, my lady, that we rely on case law. And And this is extremely important because the word new is not defined in the Criminal Procedure Act, so we have to rely on case law. I want to say, my lady, that I've seen the heads of argument by the state that they simply argue from, I don't know, my lady, but from common sense because they do not rely on case law. So it's an argument, it's not quite a legal argument. And I submit that in our case, for what we say, my lady, for each and everything that we say, we rely on case law. The first ground of appeal that we are raising, my lady, is that the investigations have been completed, and there is case law that says that if investigations are completed, this is an important new fact because it talks to interference. That is the reason that was given in that judgment. It talks to the interference with state witnesses. I submit, my lady, that when we say there is a new fact, we are not arguing from common sense, we are arguing from a point of law, and the law says it is a new fact. And this is informed by the case, my lady, of Saul, which is already part of, from the notice of appeal, Saul versus the state, in brackets, ECM, close bracket, open bracket, unreported case number CA and R93 of 2023 to May 2024. And my lady, I want to say that although the state say that this is not in fact, they are not relying on case law, we rely on case law, my lady. This is a legal argument, it must be informed by the law. And as I said, we find it from the law that it is a new fact, and we ask this court to find that it is in fact a new fact, my lady.
Would it not be in the context of how one considers investigation is completed for the interference with the witnesses? Because you must remember, it's a two-pronged approach, where one is speaking of a new fact because the investigation is completed. One could use it in the context of the police are trying to retrieve information, trying to find documentation, trying to find, so interference would hamper it. Now investigation is completed, it's a new fact to be able to consider whether or not to be released on bail. But when it concerns interference with witnesses, how would it substantiate and materialize to being, because investigation is completed, interference with witnesses is not going to occur?
Like this, my lady, if investigations have been completed, it simply means that statements have already been obtained from witnesses. It is known by the state what witnesses are coming to say. Investigations on that level have been completed. The only thing that's outstanding is for the witness to come and testify. So I, as the appellant, and I'm giving an example, I will not be able to say to the witness, please do not say this, say that, because the statement has already been captured by the state and has been obtained. So I do not know what was going on in the mind of the judge when he decided, but I agree with him that I think that that is the approach.
I think one must always look at these aspects in context, because otherwise one would be easily confused to assume that because it's endorsed in this fashion, that it automatically means it must be applicable to everything. I think we are very clear in our law as to each case must be decided on its own facts when we determine the applicability of the law to that particular case. But please continue.
Yes, my lady. Yes, that is the first new fact that we have raised in our notice of appeal. The second new fact, my lady, is it is informed by case law also, and we quote the case of Terre Blanche, where we say, my lady, that if something exists, it's not entirely new. It exists, but the appellant is not aware of it. So it exists, but it exists outside the knowledge of the appellant. When he becomes aware of it, he can come back to court and say, this is a new fact. Why? Because although it existed at the time, I wasn't aware of it, but now I am, and therefore it is a new fact. And this is the issue, and this issue will stand out in the proceedings because we raise it for different grounds, for different reasons throughout our address, my lady, is the issue of the Leonard magistrate having issued a J50 for the arrest of the appellant and then later proceeded to hear the bail application of the appellant. We say, and we say now only for the purposes of showing that it is a new fact, we say that the appellant did not raise this. And one has to have the two affidavits because in both instances the appellant proceeded by way of an affidavit. One has to make a comparison between the two affidavits and check whether the appellant did raise it in the first instance or did not. And I submit that he did not. He raised it, my lady, for the first time on appeal under case number BA45, the first appeal of 2025, my lady. It was only then that the appellant, in the course of gathering documents, he came across a J50 that shows that it was signed by the same Leonard magistrate who had his bail application. And he says, but now that I didn't know this, otherwise I would have raised it, and that's why I'm raising it on appeal. And on appeal, by the way, your learned sister, my lady, found that this issue should have first been raised at the magistrate's court.
Which we all accept to be the case.
Which we all accept to be the case. But we say, my lady, how could he have raised it because he wasn't aware of it? Now that he becomes aware of it, my lady, he goes back to say, oh, there's this issue. And what he does, my lady, is he raises points in the meaning in respect of this aspect. And we submit that on the strength of case law that says if you are not aware of a fact but later become aware of it, then it constitutes a new fact, my lady. I submit that this, for now, I'm limiting my argument to say that it is a new fact on the basis that the appellant did not know of it and then later became aware of it, my lady. Yes, my lady.
Mr. Khumalo, without wanting to restrict you in your argument, I must also remind the parties, please, this court role is very clogged. We have a lot of things that we need to attend to.
Yes,
so you're going to need to confine yourself a little to the time. Outside of me engaging you, both of us need to please just remember and be conscious of our time frames.
Yes. May I ask with respect, the court has read our papers, otherwise I don't know where to go.
This is it. No, look, I've read your papers. Yes, unless you want to tell me something that has more value because you wanted to come to the fore, by all means. I believe you would have specifically drew the court's attention to the points in limine, which you needed to highlight being the position of the J50 and the position of the DPP's decision to reinstate charges.
Yes, Malidi, in that
those two were the issues that seem to have been separated from the rest of the circumstances that warranted new facts, if I read the papers correctly.
Correctly.
Would you like to just deal with that, touch a little on the aspect of the DPP's decision, or are you comfortable with what has been placed on record in your papers and your heads of argument?
With regard to the issue of the DPP, Maledi, I submit that there's, well, perhaps as a new fact, I would like to say, Maledi, that the appellant was not appraised of the legal consequences that attach to cases where the appellant has been granted bail and then all of a sudden the cases come back for bail for the second time. We submit with respect that this violates the principle of res judicata because the court has already determined that the appellant is a good candidate to be released on bail, and the inclusion of those matters in the bail application is prejudicial to the appellant because now all of a sudden the appellant is faced with many charges in respect of which a determination of bail has already been made by a court. And
I'm just confused. If I understand the centralizing of charges, it means that the matter will only be dealt with in one court where all the cases, whatever the cases are, will be ventilated. Are you saying that your client's bail was refused in this court that was somewhere else, and that when it was centralized to Polokwane, the circumstances surrounding that bail had changed?
No, what I'm saying, my lady,
because there's a very big difference, and I need to bring it to your attention so that everybody is not necessarily confused.
Yes, my lady.
There's a difference between a joint of charges, and you might be released on bail on 5 of those charges, and then you got joined to the 6th charge, which your bail application may be premised, and on which, unfortunately, you may be refused bail. And even though you are on bail on those charges, it would not have any bearing.
Yes, my lady.
Do you understand? Is that what you say?
What I'm saying is this, my lady, and I beg leave to just explain it properly, because otherwise we will misunderstand it, and it's crucial. When the appellant was arrested in this matter, my lady, he was arrested in respect of counts 1, 2, and 3. That is the reason why the appellant has been placed in custody. Nothing else, my lady. Upon arrest, the DPP, I think on the 24th or 25th of November 2025, realizes that the appellant is now in custody. I do not know if I should use the word reinstate, because then reinstate is the wrong word to use, because in respect of counts 4, 5, 6, 7, 8, and 9, the appellant was in the past out on bail in respect of these charges. All of them, 4 to 9.
So what, wasn't he appearing in court on those cases?
They were withdrawn already, my lady.
Right, so now there's a very big difference. We cannot talk about being on bail. We talk of the charges were withdrawn, he was free. He could go and do as he pleased until and unless the state decided to reinstate the charges.
Correct.
So now we've got a better picture. Mr. Khumalo, let me correct you so that you and I never get wrong again. If he's appearing on 1, 2, and 3 and he's in custody on 1, 2, and 3, that means he's appearing in court, the case is proceeding against him in 1, 2, and 3. If the state decided and elected to reinstate, because that is what the right word is, reinstate the criminal charges that were previously withdrawn, whether it was 1 year ago, 5 years ago, or whenever. That's DPP's prerogative, obviously. And as the state, they can decide, because the charges were drawn, they want to reinstate the charges. Then 4, 5, 6, 7, 8, 9, or whatever the other charges are, will be then added to the proceedings of the current matter. So, whether he was on bail on 1 charge then, or whether he was on custody on 1 charge then, the fact that the charge was withdrawn means, in effect, that there is no more a case in court, he is free, unless and until the state decides to proceed against him. If he is acquitted and if he's convicted and sentenced, then the words res judicata will come into play. Do you understand? Because then the court's word was final. The court couldn't say anything more. But a withdrawal never, ever tantamounts to an acquittal or a conviction in law.
My lady, let me explain properly, because I want us to be on the same page. My lady, the issue of bail in respect of counts 4, 5, 6, 7, 8, and 9 has already been determined. What is the correct procedure for reinstating? Let us start here. What is the correct procedure for reinstating matters, my lady? Is by issuing a J175. If the state sought to reinstate these matters...
Look, the state can use various means of securing a person's attendance in court. Let's not get bogged down by those principles. You can be warned to come to court. You can be summoned to come to court. You can have a warrant of arrest issued for you to be brought back to court. Depending on what the circumstances were that the state saw fit to litigate that person. Do you understand?
I understand what
you're
saying.
So whether that decision was an incorrect or a correct decision, obviously one has principles of legality, Haja, to be able to find recourse if one is questioning the manner in which the person's attendance in court was secured. Ultimately, it is to bring that person to court. So we're not going to get bogged down by that. I just was confused about this on bail, because when one talks of centralizing cases, a person could be on bail in Mokopane, he could be on bail in Lebohomo, And when they bring the charges together, then all those charges get added to become part of the record. And then, depending on how they decide to centralize it, which is again the state's prerogative, that person will be informed, your bail is extended, you are warned to go to Polokwane Court on this case. Or your bail has been revoked, you are now in custody. Or you would be in custody or on bail pending the outcome of your matter, wherever that court is going to be. So that's what I was trying to figure out with you when you spoke of being on bail. If the charges are withdrawn, then you're a free person. That's that case was dead. It's no longer, as far as that case number and that charge sheet is concerned and that courtroom, it's no longer applicable. You would have been refunded your bail in respect of that case. I'm sure you're alive to that.
I'm alive to that, but what is made, Malady, is, and let me just make this point and perhaps move on.
Move on, yes.
Malady, a court at some stage made a determination after considering all the facts in the application and said to the appellant in the past, I am satisfied that you are a good candidate to be released on bail. Then the issue of bail has been determined, you are out on bail. And then, later, the state, with the same charge where a determination has already been made by a competent court of law, they come and require that another bail application be held, sort of testing the tested already. I say, with respect, as I said, Malady, I'm just making this point and then leaving it for the court to make a determination on it. Yes, Malady. May I just leave this aspect and then consider answer? Thanks, Malady. Malady, the appellant in the bail proceedings of the court of law testified through himself and also through the doctor that he led.
Was he not testifying or was he not by affidavit? Because you initially said in the bail appeal he did an affidavit.
He did this, Malady. He used an affidavit and thereafter
he went and testified.
He went into the witness box for the purposes of cross-examination. Yes, Malady.
Okay, no, because that's what I was just a bit confused about, because I do recall that there was evidence led.
It was led through an affidavit, correct, Malady. The court correctly picks it up, that it was through an affidavit.
And then evidence under cross-examination.
Yes. Correct, Malady, correct. So what we are saying, Malady, is the appellant says something extremely important, and this is supported by his doctor. He says that he's not receiving, well, I'll deal with the other aspect supported by the doctor. The doctor doesn't talk to this. He says he's not receiving medical care while in detention. And I say this is new. Although he said in the earlier affidavit of the first bail application, Malady, that he was in pain, but no mention was made of the fact that he was not receiving medical care. And I submit with respect that this is new. And our submission is also supported by the implied admission on the part of the learned magistrate, because what the learned magistrate did, Malady, and this will correct the submission made by my learned friend for the state, because they are saying the witness from correctional service was called by the state.
No, it was the court witness.
It was a court witness, Malady.
Yes.
So they are saying it was a state witness, but
it was just possibly an oversight. We can't blame this particular state official. Obviously, he was not the one of the document.
Correct, Malady. Correct, Malady. But as we are dealing with misdirection, there seems to be some misdirection on the part of the state, and I'm saying this lightly, Malady. But the point we are making on a serious note, Malady, is the learned magistrate, by calling that witness, and we say this with the greatest respect, kind of treated this aspect as a new aspect, because otherwise there was no need for him, if it wasn't new, there was no need for him to lead further evidence from a correctional service officer. So we submit with respect that the mere fact that the learned magistrate realized that this issue requires an answer, and he took it upon himself to call a witness, was an implied admission on his part and recognition of the fact that this was new, and therefore the finding that there's no new fact is self-contradicted by his action, Malady. And I move away from this aspect. But our submission with respect is it is a new fact, and the learned magistrate treated it as such in the course of the proceedings. My lady, there's another...
Might I ask Mr. Kumalo, I didn't see from the record of proceedings ever, but maybe I was not looking so very clearly. Did the appellant ever approach the court on the many occasions that he appeared, wherein he sought the court's involvement and assistance for the court to order medical treatment, whether it be psychological or physical? Because I did not see it. And normally one would find that you, as counsel representing your client, the accused person in the district or regional court, you'd place on record on that appearance in court, most importantly, please have the detention warrant read that he needs to be seen by a medical practitioner, or he needs to be seen by the doctor, or he needs to be seen by whoever for whatever purposes. And then an endorsement is made. Or we asked for it previously in court, we never got helped previously by the department or the investigating officer or the whoever. Please can the court now order for this to be done? And I did not see, because I was looking for that aspect in the proceedings in the court of call and the proceedings that were before the magistrate.
Yes, lady, may I acknowledge that I wasn't involved from the outset in these proceedings, and in the course of my involvement in this matter, we did not raise it, except on one occasion, my lady, and that was last week, and that was after the completion of the proceedings, and it was in the regional court. My learned friend as an officer of this court will probably agree with me that it was in fact raised last week, when, or 2 weeks ago, sorry, when he appeared that he requires assistance and the learned magistrate in the regional court. But I acknowledge the fact that it doesn't form part of these proceedings.
No, look, I appreciate that, but it was then only ventilated now when you went to the regional court.
Correct, my lady. Correct, my lady.
And since you were so generous to share that information with me, what is the proceedings happening right now in the regional court? What is going on?
My lady, we appeared for the first time on the 15th of May this month, and we are appearing again tomorrow, my lady. And the appearance tomorrow is for the finishing of copies of the docket. My lady, may I take advantage of this opportunity and also mention, my lady, that the matter is going to take time on the roll of the regional court. There are matters which came before it which are still awaiting the trial date. Trial has not commenced. It's common cause, it's known by all parties that the roll is often congested, and it is the case in this case. And we submit with respect that if bail is not granted, the appellant will only start his trial much later, and this would negatively affect him. And he does state in his affidavit that he is running out of funds. His wife and daughter, newborn daughter, which is a new fact, are facing an eviction, which is a new fact, my lady. We submit with respect that if the appellant is not given a second chance, and that's all we're asking for. We're not asking for the withdrawal of the matter, my lady. We're asking for something so
second chance. How many of the second chances? How many counts was added to this particular charge where there was 3 charges originally?
A lot, I admit, my lady.
So how many chances would that have been? Because we're talking about different periods of time in different stages of this person's life where he had conflict with the legal system. Individually, independently of each other, we didn't know at that stage when he was getting those many first chances that we wouldn't be here today concerning ourselves with a second chance at an appeal, at a second chance of an application on new facts.
May I rephrase, my lady, and I acknowledge what the court has said. As an officer of this court, may I change and say we ask for a final chance.
A chance.
A final chance, my lady. A final chance, my lady. And we ask and we undertake before this lady that if given that final chance, my lady, the appellant will not be arrested. But may I say, my lady, that despite the fact that there are quite a number of charges, and I admit that as an officer of the court, that when you look at his history, previous convictions, if I stand to be corrected, my lady, I think there's only one. So
I didn't even focus on the one previous conviction. because obviously the offence was of such a nature that it fell within the ambit of Schedule 6.
Indeed, my lady. Indeed, my lady. But I ask with respect that there are allegations that which have not been tested yet, that he has been in conflict of the law. There are cases which have been opened against him, and these cases remain to be tested through trial. And the trial is only going to start some years later. And we ask that in the meantime only, he be granted bail, my lady, with suitable, stringent conditions suitable to his circumstances, my lady. My lady, on all occasions in the past when the appellant was granted bail, he attended court, my lady, until such time that his matters were finalized in the one way or the other. So I say, if given a final opportunity, the appellant will grab the opportunity with both hands, understanding that this is the final chance, my lady. My lady, the other new fact that we are raising is, if you look at the record of the court accord, it is clear that the state did not need evidence to oppose the application of the appellant. And I argued at the court accord, my lady, that if the state did not want to waste time, they could have called the investigating officer to ask only a simple question: are you opposing? Yes. What are your reasons? And he could have said, my reasons are as before, and close it, my lady. At this point, I'm saying a wise man is allowed to change their mind, and the state seems to have changed their mind. What we are sitting with, my lady.
No. I think we'd be presumptuous when we say a wise man has changed his mind by keeping quiet. I believe very strongly from the reading of the record, the prosecutor just said, I'm closing my case, there's nothing here that I need to rebut. The onus still rests on the appellant in this court, the applicant in the court accord, to prove their Schedule 6 application on new facts. If they haven't satisfied the court there's new facts, then I'm not going to rebut it. I don't need to rebut it. I don't need to say anything because it's still based on the previous case. So would it not be proper then for us to stand here and say, with a clear mind, that that person had actually chosen by their silence to be in agreement?
My lady, the principle is if there's evidence before court and that evidence is not opposed by the opposing party, it stands uncontroverted, and therefore the only evidence before court. My lady, look at it this way, please. The appellant comes, he gives evidence, and he also calls a doctor to give evidence. The only way a party who's opposed to the evidence of the doctor can effectively challenge the evidence of the doctor is to call their own doctor.
He doesn't need to. What does he need to do this for? Remember, this is not a trial. This is you, as the appellant, coming before this court to say, I have new circumstances. I need you to revisit what you've decided previously on this new aspects. The respondent has the choice, after hearing what you presented, to say, it's such a lot of new factors that I have to agree that you should be released, or I have to need evidence to rebut what you've said, or I can choose to close my case, resting on the fact that you've showed nothing. And in my argument, I will rely on what was your previous circumstances, because that's where we're going. You have to look at what was before to be able to determine what was old and what is new.
But
nothing new has come to light. Do you understand?
According to them, according to us.
But this is what I'm saying now. For you to say a wise man has elected to choose not to rebut the evidence before the court because he accedes to the evidence, that's stretching this wise man's ability. Because we know from the evidence before the court that wasn't the intention of the wise man. He never acceded to anything because in his heads of argument he was very clear concerning what he believed to be the situation. So I think maybe, Mr. Kumalo, you and I must both be in agreement and align ourselves to the fact that he opposed the application and elected to close his case without needing rebuttal evidence. Whether that was smart of him, whether that was not smart of him, that is entirely for what that court decided. And in the quota quo, the court aligned itself to his argument.
Malini, for us to say that the state was opposing the bail application would be speculating, because ordinarily this is what happens in bail proceedings, Malini. At the outset, the state makes it clear we are opposing or we are not opposing. In this instance, nothing was said, Malini, so we don't know for a fact.
No. Remember, you're not coming on day one. You're coming on the second bite. This is day 2. You've already been before the court. It was previously opposed. There was evidence already led. Everybody decided how they were going to stand in respect of that matter. And then the court made a finding. That finding was taken on appeal, and that finding was found to be good, and the appeal was refused. Your client, with this new facts, went before the court a second time. But this is not the first time. So you cannot say this is a new bail application. It's just an application on new facts from the previous bail application. You still stand by your bail application.
Malini, just because the bail application was previously opposed, it doesn't come automatically that the second bail application is being opposed. There are many instances where in the first instance they oppose, but in the second instance they realize, for instance, that investigations have been completed, and therefore, as I said, it's a new fact, and therefore we do not feel
okay, well,
the same
look,
way we felt.
I hear you.
Yes.
I will take your point. I don't know whether that point is a new fact, but I will take your point.
That one is we not dealing.
It was never ever a new fact.
No.
Never a new fact.
Oh, no, sorry, man.
Yes, because that's what you were going towards, and I was wondering why you were going towards this point.
May I just reassume my position? Malini, what we are saying is let's make a comparison between the first bail application and the second bail application. Let's make a comparison. Was evidence led for the opposition of bail in the first instance by the state? The answer is yes. On the second bail application, was evidence led by the state as an indication that they were still opposing the bail application? Now, what we know is that when they opposed, they lead evidence. Did they lead evidence this time? No. And our submission is the state, perhaps I should put it carefully, shouldn't get into their mind and say they changed their mind. But I'm saying the approach that they are taking is now different to the matter. If they are opposing, perhaps not as vigorously as they did before, does this not present itself as a new fact? I submit that it does, Malini, because the reconsideration of the bail will have to be now made on the understanding that there was vigorous opposition earlier, but now there isn't at all. And I've even said, Malini, and it's there on record, to say the investigating has been coming, he's there sitting there. And the assumption is that he's here to testify, and they decide not to call him as a witness, perhaps because they realize that we should not be opposing this bail application anymore. And I said, Malini, may I just close this aspect by saying, just because the earlier bail application is being opposed, it should not be therefore presumed that even the second will be opposed, because in most instances we find that the state change their mind in the conduct of their case. And I submit that it is a new fact that the state has decided not to lead evidence in the opposition if they are, and I submit they are not, of the bail application. And then the magistrate calls a witness, Malini, and we say the evidence led by this witness, Malini, is of such nature that it doesn't clarify the provisions of the Criminal Procedure Act on bail and also on trial. If a court calls a witness, the purpose of that evidence should be to clarify issues, but with this witness, and that's why I don't blame my friend from the state who drafted the argument to say the state called the witness, because when you listen to the evidence, the assumption is that this witness has been called by the state because he goes deeper into the merits to challenge what the appellant is saying. And I submit that that was a material misdirection on the part of the learned magistrate who came down, and I say this with respect, and it's often a challenge on appeal that you have to show that the decision was wrong, not to disrespect or anything.
I must ask, was this part of your heads of argument, or was it
Yes,
part
indeed.
of your...
It was part of the notice of appeal, and it was also part of the heads of argument.
Take me quickly to it.
Yes, it is on 5.3 on the heads of argument, Madam. Yes, it's on paragraph 5.3 on the heads of argument.
Okay.
And on the notice of appeal, it's there, Madam. May I just find it quickly?
Yes, please.
Yes. On the heads of argument, it's on page 5.
The
paragraph
heads of
2.
argument, yes.
So, not in the notice of appeal, Madam.
It's not.
It's there.
It's there.
It's
Paragraph.
on page 5.
Yeah.
Paragraph 2 of the notice of appeal, saying, calling a witness from the Polokwane Correctional Center, whose evidence served not merely to clarify certain aspects as required by the law, but whose evidence went beyond to challenge and discredit the evidence of the appellant. So it's there in the notice of appeal, it's also there in the grounds of appeal. And may I say, my lady, that the state does not say anything about this, because what can you say when the evidence called by a court challenges the evidence of a party? And that should not be the case, my lady. And I submit with respect that this is a serious misdirection on the part of the learned magistrate, and we say this with respect, please. We are called upon in terms of the law to show that the decision was wrong, and we say the progress or the process followed by the learned magistrate actively involving himself in the proceedings and not just consuming evidence is a material misdirection on the part of the learned magistrate. And it is on this basis that we submit my lady that section 65.4 has been satisfied, my lady. I'll wait to hear, because on their papers the state does not say anything, but it's a very important aspect, my lady. When you listen to the evidence in its entirety, you make the mistake that the state is making, thinking that this is a state witness, my lady.
Would you not consider the fact that, I should ask, this dialogue that we are having in respect of it, would it be an argument raised that this court is descending into the proceedings? Or would one look at it in a different context?
May I understand the question, Marie?
It was very clear from the appellant's arguments that's been made that the presiding officer appeared to have descended into the arena to involve itself into the matter.
Correct.
Now, I'm asking, our dialogue, this communication that we have been having, concerning points that you are raising, which you are being questioned about and ventilated on, would that not be seen as descending into the arena?
No, not at all, my lady.
Okay.
A court, in the course of arguments, has to engage us. And it's very important. I appreciate this, because we do not want the court to go into chambers and assume certain things. It's important to hear from us, so it's allowed. But the moment you call a witness, my lady, this is completely different.
But in bail applications, isn't there a greater role that the court plays as far as its sui generis nature? Because it's not a trial, but it's to lay bare as much facts for and against. Because we do not know what that witness is going to say. And for all intents and purposes, there was lots of information that came forth from that witness concerning, and it was conceded to, the procedural divisions where one does not necessarily, and I use this very literally, the right hand does not necessarily speak to the left hand, and that is why possibly the issues at the Department of Correctional Services was being ventilated. So your complaint concerning the fact that nobody was willing to help you needed to be testified to insofar as why did you not help this person? Because without it, we don't know what the situation is.
Malini, I submit that the right person who should have taken that step of requiring that evidence is the state. Because I am saying this piece of evidence doesn't just clarify things, Malini. It opposes what the applicant is saying. The applicant says, I'm asking for medical care, I have not been given. And the witness comes and says, no. That essentially goes to the merits of the applicant's application. And it's in my view, I humbly submit, Malini, that the magistrate, with respect, and I say this with respect, went too low. And I say this with respect, I emphasize, Malini, when information has not been placed before you, you have to be careful that the information that you're asking for, it should not be to the detriment of the party who's presenting evidence. The moment that is done, then you are not just adjudicating on the matter, you are opposing the matter. And I say this with respect, Malini. This evidence should not have been called by the court, it should have been called by the state, Malini. May I leave this issue to say, this, Malini, is a new fact, and the learned magistrate treated it as a new fact. Otherwise, the magistrate would not have bothered to call a witness from correctional service. They called a witness because they realized, we are hearing this for the first time. It requires attention. So I submit with respect that the learned magistrate impliedly admitted and treated it as a new fact, but failed in the course of making a finding to rule it as a new fact. So it is a new fact, hence so much attention was given to it. Even if you look at the judgment, there is so much that is being said about this. Does it make sense that you give something attention while you say it's not new fact? If it's not new fact, then you don't even deal with it, Malini. I submit with respect, Malini, that this constitutes a material misdirection on the part of the learned magistrate, Malini. And by the way, Malini, under cross-examination, this witness makes a number of concessions. I will not go through them. They are contained in paragraph 5.5 of the heads of argument. But what is concerning once again is when one listens to the judgment, the learned magistrate does not deal with the concessions, deals with the evidence that was given in chief. And it is not too surprising when one considers that, by the way, the witness was called by the magistrate himself. Hence, when you analyze the evidence, you only pick certain aspects of the evidence.
I don't believe that from reading of the judgment that the magistrate went into great detail concerning contradictions of any of the witnesses, especially the applicant in the bail application on cross-examination.
Yes, Malini, may I say that it has now become important for me I had said that I will not repeat it, but it has become necessary for me to do so, Malini. The witness makes certain concessions, and they are the following: that the person who has to...
No, I didn't ask you about the concessions. Please hear me nicely.
Yes, Malini.
We're speaking here about dealing with the various concessions that were made by this witness, which the presiding officer had called, which the presiding officer then in his judgment chose not to critically analyze. Now, I'm taking that argument further by asking the appellate counsel. From the reading of the judgment, one would note that the court did not critically analyze any of the evidence that was led to find fault, to find criticism, to find praise, to find acknowledgement and support.
I agree with the court.
So, as far as that is concerned, it applied to everybody.
I agree with the court, and we say, Malini, with respect, that was a material misdirection on the part of the learned magistrate, because the concessions that the witness made changed the entire evidence of the witness. it changed the entire shape and form of the evidence because the concessions reduced, and we say this in the days of argument, they reduced the evidence of the witness into nil, and we say with respect because...
So if it was reduced to nil, then of what value would it have been to then want to critically analyze it? If one is not going to be focusing its attention entirely on that. Because from the reading of the record, it was not the be-all and end-all of the refusal of the bail in the court quo.
What concerns us, my lady, is when you make reference to the evidence in its entirety, you should not only look at the good or the evidence in chief, you should also consider the concessions which were made under cross-examination. And we are saying the learned magistrate went quoting from the evidence, even if it's not entirely. They chose only the soft part, and the hard part they ignored with respect, my lady. And I'm saying the concessions are very important because this is what should have been quoted from the evidence because it sort of neutralized the evidence in its entirety. When the witness admitted on record that there was no requirement on the part of this person, the appellant, to endorse in the register, it is in fact the duty of the correctional service officer. But when you look at the evidence of when you look at the codes preferred by the learned magistrate, they go back to the evidence in chief that a report has to be made, but no mention is made that who has to make that report, Malini. So I say there was this approach that was given, and this approach was quite picky, if I may put it that way, Malini, only choosing the good part of the evidence, Malini. Malini, I'm standing here trying to show that the decision was wrong, and I request not to be misunderstood, to disrespect the court, but I have a duty, as I said, and I think I'm saying this for the second time, to show that the decision was wrong. And on this basis, I submit with respect that we are only trying to show that the decision was wrong and the discretion was exercised wrongly by the learned magistrate.
Anything else?
Aleni, when making the balancing act in, may I deal with this aspect? And I appreciate the court is engaging me that I can clarify this because we raised it in the notice of appeal and so did we in the heads of argument. The learned magistrate then makes the following remarks, and I'm reading from paragraph 5.19 of the heads of argument, and I quote, "It becomes arrogant and can deceive public perception for the defense counsel to even imply that a judicial officer who signs a J50 cannot preside over bail application." That is the first one, my lordship. The second one is that furthermore, this can be viewed as an attempt by the defense counsel to throw the judicial officer under the bus. Malini, let's try to get into the mind of the learned magistrate, but he makes these very serious remarks. Was he, and I have to be careful how I put it because I want it to sound as good as I wish it does, Malini. It sounds to me, and if I'm wrong, please tell me now, Malini, and my learned friend will correct. It sounds that the learned magistrate is not happy, and I'm trying to be as economical as possible with words. It sounds like the learned magistrate is not happy. If anyone agrees with me that a person can only make these remarks when they are not happy, can we say that he exercised his discretion judicially? And this is what is required. When you make a decision, Malini, in bail proceedings, it's a discretion that you are exercising. When you make these remarks saying that the counsel is arrogant, and if anyone disagrees with me, please show me anywhere in the record of the court of law where I sounded arrogant, and I'll apologize now.
We'll be doing a lot of apologies for everybody if we had to keep phrasing our words and worrying how it is perceived. I can call it black, and you will hear me saying it's white. It's what you hear and how you deal with what you hear that matters. So I appreciate what you've highlighted. Mr. Khumalo, it's not going to take us any more than where we are right now by trying to ventilate whether or not you sounded arrogant when you said that that was an irregularity, that the court should not have decided this J50 and then presided on the bail application.
Our closing argument in this aspect, my lady, I appreciate what the court is saying. In closing this aspect, and I'm saying, my argument, my lady, is when a magistrate, learned magistrate, makes these remarks, it seems, and we say in paragraph 5.20, that the learned magistrate assumed a personal approach in the matter when you start looking at the parties themselves and not the merits of the application. And we also say that it seems that prejudicially he made the decision to refuse bail based on this, my lady, because this seems like a very strong expression of a feeling, my lady. And my lady, we submit with respect that when one makes a decision under the circumstances.
I believe those were the points in limine. They were not grounds for new facts.
It is ground, my lady.
No. In the court quo, you raised it as points in limine because you didn't know where to place it.
The issue of the J50 was raised in the points in limine. But obviously when raising those things, we didn't know that the magistrate would come and make these remarks.
No, look, I appreciate that this is your grounds of appeal.
Yes,
but for all intents and purposes at the hearing in the proceedings, it was a point in limine ancillary to the bail application on new facts. But I'm raising these as points because I really don't know where to fit them into the equation. So I just want to bring to the court's attention two irregularities which has been addressed or assessed by the applicant in my bail on new facts that I need to bring to the fore. And the one was the issue of the state and the charges being brought with the bail application being brought together, and then the second being the J50 and the presiding officer seating on the bail application. You agree that was points in limine. You highlighted it even in your heads at that proceedings, and you addressed it as points in limine, which would have been in a civil proceedings ancillary to the main issue. It could have an effect, but one would have to weigh it with the other factors.
Yes, my lady, the issue of a J50 comes twice or many times in the affidavit. It comes also firstly as a new fact, which the applicant wasn't aware of, and we support this by means of the law to say, when you become aware of it and then raise it, it should be treated as a new fact because you were not aware of it at the time of the earlier bail application. So that's how it comes. Firstly, as a new fact, but secondly, as now that I know this, I'm raising it and I'm raising it as a point in limine. So it comes now for the second time as a point in limine.
I just want to confirm.
Yes, ma'am.
When the J50 was executed, it was on account of the accused being out on bail, and he had to be brought back to court.
It was
Correct.
in respect of one specific matter, in respect of which he was out on bail in the Wahoo. That is correct, my lady.
And on that J50 he was then brought back to court, and that's when all this transpired.
That
or
is
how did it happen?
No, the court is correct. He was arrested while he was outside on bail.
For a charge already that he had been given bail to.
No, when he was arrested, my lady, he was arrested for a new charge for October 2025. At that stage, he was already out on bail in respect of a matter in the Wahoo.
Okay, so let me get it straight. Was this J50 issued in respect of the first three charges?
That is correct, my lady.
So there they got a J50.
Correct, my lady.
Thank you.
Correct, my lady. Correct, my lady. My lady, we raise issues which in our view, my lady, constitute exceptional circumstances, and obviously these issues will only arise if the court finds that there was misdirection on the part of the learned magistrate on his finding that there was no new fact, whereas there are a number of new facts, and we submit on the basis of what the law says. My lady, I wouldn't imagine my learned friend for the state to stand up and argue against the law, because what we are saying is the law. I cannot imagine, my lady, a judgment that comes, my lady, and says there was no new fact, whereas the law has told us, my lady, that these issues, when they come up, they should be treated as new facts. We find information from case law, as I said earlier. Case law tells us what constitutes new fact, and I've raised aspects that I've supported in case law. I find, my lady, and I ask the court to do so, that there are new facts, not one, not two, quite a lot, my lady. I'm not sure if I should rephrase something.
No,
yes.
You don't have to. Is that all that you need to place before the court?
Let me just make sure, my lady, and I know we're placing against time. My lady, may I just refer the court to paragraph 6 of the heads of argument, where we deal with section 60, subsection 9, and that is the Balancing Act. We consider all these aspects. The trial is going to take too long. He has been in custody for too long. And I think we ask with respect, let us not put another burden on legal in South Africa that has to assist people who are struggling financially. This applicant.
Oh, I wanted to just canvass one aspect with you before
Yes.
we close on the subject.
Yes, ma'am.
The new fact being the debt that he's now incurred because he wasn't able to attend to a function which he had booked and been prepaid for, 65,000 rand, I believe it is.
Yes, ma'am.
Why did his wife pay back the money?
She doesn't have the money. That's
No,
why-
but they took the money from these people. She's the manager.
I think-
She does the booking and she does the planning. So I want to know what happened to that 65,000 since he was not able to attend and he was in custody, arrested now on this case. Why didn't this money get refunded?
Let's be careful not to already adjudicate on that civil matter, my lady, because
No, you brought it up. I must ask you about it. I'm not adjudicating it. I'm asking you relevant questions because from your supporting affidavit of his spouse or partner, life partner, she indicates she's the one that does the booking, she's the one that does the arrangements, she is in partnership or she is in support of the other person that is also there who I think does the setting up and the locations and things like that. But my problem was you raise it as a new fact. It's a consequence of your incarceration that you are now facing civil litigation. I don't want to go into the litigation. I just want to know why wasn't the money refunded since it was paid up front?
I mean, with respect, may I ask with that question, and it's a very important question, but may I ask that we should not deal with it here with respect, my lady, because there are impending
Pending matters.
proceedings.
Okay, then you shouldn't have brought it to my attention when you wanted to bring your bail on new facts.
My lady, how I brought it up is as follows. I'm saying there is now an action
Yes.
that is being brought against the appellant, and I'm saying this action did not exist at the time of the area bail application, but it exists now.
Okay.
Firstly, it is a new fact. Secondly, he has to deal with the matter. How he's going to handle his
Is it
defense or not
business?
is a topic for another day. But I'm saying, and I insist, that it is a new fact. Why? Because did it exist then? And if the answer is it didn't, then it exists now. It's a new fact that if we get to why the money wasn't refunded, I fear that we might be losing it a bit, Malindi. And
No, look, I appreciate your candidacy. I just wanted to know because it tweaked my brain that I didn't realize at the time when the affidavits were all being presented and the evidence was placed before the court, that she would have been partly involved because she's part of the business. I didn't read or take cognizance of the fact because I relied on his evidence more than anyone else's concerning the application for new facts. And I thought it quite intriguing when I read her affidavit, and then I read that there was now the summons issued. And I thought, okay, so this would be a factor that would be considered. And how it would be to just to ventilate that issue, to just ask.
Yes, Malindi.
But more for my benefit than for your proceedings. Whether it has weight or not, it was just for me to find out because I thought she was somehow not party to the businessing. And then I read it later in an affidavit that she was part of the businessing. So,
Yes, my humble request, my lady, is...
leave it alone.
Well, I can't say that to the court, but I'm saying, is it a topic for this matter? That specifically, I say with respect, it's a topic for the impending matter, my lady. And I ask that it be reserved for that court. But what we are saying is, it is in fact, and it is on this basis that we ask that the matter be reconsidered. And I ask a simple question. It's easy to tell whether it's a new fact or not. Did it exist then? The answer is no. Did it exist now? Yes. Did the court have to deal with it in its judgment later, earlier, sorry? No. Did the court now have to deal with it as a new fact? Yes. Is it a new fact? Yes, it is, my lady. Thanks, ma'am.
Thank you, my lady. My lady, I am going to submit that there was no misdirection by the court of law in finding that the facts presented were neither new or discovered after the initial bail application. Maril just been submitted not long ago by my colleague, in essence criticizing the magistrate for calling a witness. I submit, Maril, that in the era that we find ourselves now, where this country is run by a constitution, it cannot be expected that the magistrate will just sit passively and listen to whatever is being submitted without engaging or not even acting actively. And I wish to refer the court, my lord. If I drafted the heads of argument, I would definitely have filed this heads of argument, rather this decision.
I take it, Mr. Kumalo, you're going to have no issue as far as the deviation from the heads of argument is concerned on this issue. I think it would be more in response to what you've now said than more to what you wrote.
Well, my lady, I would, and I'll explain why. There's only one institution called the DPP with various provinces, offices, my lady. So if they make a bed, they should lie on it, my lady. You cannot come and now blame your colleagues to say they didn't include this, they included that, and therefore I should be allowed. I oppose on the basis that this morning what he should have done if he wants to divert is he should have filed supplementary heads of argument based on which he wants to argue. So I do not accede, my lady.
Would you like that opportunity?
But I would love that opportunity for the court to give me. I would love that opportunity. But as I was addressing the court, my lord, I have to refer to case law, and I accept that I have not furnished my colleague with any this morning. But it would be unfair for me to address this court without making any reference to case law.
Are you going to be the one that's going to be moving the response in respect of this appeal?
Indeed, so.
Okay. Mr. Kumalo, what is your response to the question that was asked by the court, and then in light of what you've highlighted and in light of what the state has just placed before this court?
I maintain what I said, but obviously the decision lies with this court. I have a strong feeling about it that if my learned friend wants to deviate.
No. He is seeking the opportunity to be able to provide supplementary heads of argument wherein he argues what he is going to speak, and you have an opportunity to see what he argues, what he is needing to speak, and opportunity to file a supplementary head of argument if necessary.
My lady, with respect, I was sitting here, I may have missed it, I did not hear him
It
say.
was 2 seconds. No, he didn't say. I asked. You are asking to tell me things that you would have liked to have cited in case law. You did not compile the heads of argument. Would you like an opportunity? And that's when he said he would really appreciate it. He loves it. Didn't you hear that part of he loves it?
Let me say what I heard, my lady. What I heard, my lady, was, are you the one who's going to argue this? And he said,
That was
yes.
the next question that I asked.
I missed it, my lady.
Okay.
I missed it.
Would you be opposed to the idea of your opponent having an opportunity to file detailed heads of argument that he is now going to be arguing in the supplementary heads of argument, and which you would be afforded the opportunity to respond to with the supplementary heads of argument?
I would be opposed to it, and let me explain why, my lady. My lady, we filed the appeal on the 19th of May. The following day, and we appreciate this, we heard from the office of the Honorable Judge Malini informing us to prepare ourselves and to file his on day before yesterday, Malini, on the 25th, if I'm not mistaken, Malini. That was sufficient time. I've had appeals done for 3 days, Malini. You file today, you are called the following day for the following day, Malini. I say we have been given sufficient time. They have filed heads. It is going to be, in my view, too much if they get more time, whereas all of us have been given time. From last week, almost a full week, my lady. It's on that basis that I submit, my lady, instead of wasting time, perhaps my learned friend can just proceed and speak to what is contained in the heads of argument and maybe outside, so that we don't waste any more time, my lady.
No, you can't speak to outside because you just oppose the outside.
I'm saying it's a
It's a damned if you do, damned if you don't situation, Mr. Kumalo.
it's a better devil for us to proceed today with him touching on the contents of the affidavit and also touching on the heads of argument and outside, than for us to come back on another day, maybe, to argue once again. So I'm saying I'm reconsidering my position. Instead of having the matter adjourned for them to prepare, he may, if he's ready, we might as well just deal with all the issues contained and not contained.
How would you be able to ventilate it in response? I'm just worried. You know, this is one of those things that the minute you go outside, we don't know what is going to come. I don't know because I haven't seen it. I haven't prepared on it. I don't have an idea of what it's going to be. So it's a different kettle of fish altogether, because what it's containing, we have no clue. You would not be able to be in a position to rebut by your argument in reply. And whether that's to your client's prejudice, or whether it's to your prejudice, or whether it's to your advantage or to your benefit, I will not know. And that's the uncertainty. So I hear you that you're opposing the request in respect of the application. I can't hear you as far as stepping back and saying, I don't mind, he can talk about everything and anything, because that we just cannot allow in legal proceedings, unfortunately.
My lady, when my learned friend from state came and stood up, he didn't ask for a postponement, so I assume he's ready to proceed. It was through engagement with the court that
we found out 2 things. One, that he did not draft the heads of argument, and 2, he wishes to now address on case law and on issues which he believes would be in the interest of justice that it be brought to the attention of a court. And we found out that that should have been done by means of a supplementary affidavit.
May I please put myself in the hands of this court, please? Thanks, my lady. I welcome any decision by the court.
I appreciate that.
But if I may just clarify, if the court looks at the heads of argument, they were submitted yesterday, the 26th.
Yeah.
And
it was extremely...
I'm here to argue the matter because my colleague is in court at the moment, but I'm ready to proceed. I'm ready to proceed, but because of what my colleague is saying, then...
Okay, but now you can't be on both sides. You can't be on the side that you would like for the opportunity, you would appreciate the opportunity to provide the court with what you say would be the circumstances justifying why the bail in the court of quo as far as its new facts were not being proven to be met, and you would like to provide this court with the relevant case law in rebuttal of the heads of argument by the respondent, by the appellant, who said, I relied on this case to say that the matter is obliging of the court to take cognizance of, whereas the respondent just speaks from the top of his head,
Yes.
without any reliance on anything.
Yes.
You want that opportunity to respond because you do know of one or other case law that you can seek
Indeed
to
so.
support what you are saying, and you want to also, according to what you told me, answer a few of the other aspects, especially concerning the last point in respect of our constitution
Yes.
and our freedom to be able to speak even as courts. So you need to help me, because I asked if you wanted an opportunity, because I do not want our proceedings to become blurred by people addressing the court and putting information before the court that has never been placed before the court before. That is not how we litigate. We know how to litigate properly, especially when we are within the parameters of a bail appeal. And it's based on that that we then deal with the matter appropriately. So, is that what you were seeking?
That is what I'm seeking, my lady.
Right. And it is opposed by your opponent. I had the opportunity to listen to Mr. Khumalo in his argument before the court. And there is various aspects in his argument which I took cognizance of, as far as there being, as he very correctly highlighted, scant or no comment on the part of the state. And that specific reference was made insofar as the issue pertaining to the relevant case law that was being relied upon, as well as the arguments pertaining to the issue of the state concerning whether or not the state, by its silence, acceded to the new facts being grounds on which bail could possibly be considered. I've also took cognizance and note of the fact that the state advocate appearing today was not the state advocate who filed written heads of arguments yesterday. I also appreciate the fact that in this particular matter, a lot of pressure has been put on the parties, because a date was given very quickly after the matter was sought for leave to appeal, or appeal on the bail appeal on the new facts from the judgment of the court of law, that everybody had to scurry. And I must take cognizance of the fact that the office of the state advocates have not only got one client and one matter. Unfortunately, they have many clients and lots of matters, and to say that this court must expect this particular counsel to argue fervently in respect of the heads of argument that was filed, where he starts his address by placing before the court the fact that it wasn't his documents, nor was it his thinking, and if it was him, he would have filed proper case law in support of the various arguments. I cannot but believe it's in the interest of justice, not only for the appellant, but for the respondent, to put the correct aspects, highlighting the relevant information for this court to make a proper adjudication on the issues. It's not a simple matter where one can say, off the top of my head, I want to tell the court 50 million and 10 things, and the court must just trust that what I'm telling the court is the law, because without the proof of it, I won't be able to go and Google search and see whether you're telling me the truth or not. And it will be too late then to try and question you on what I didn't find, because you decided to use AI to support your argument without looking to see whether the AI was right or not. Be that as it may, I've come to the conclusion that it would be in the interest of justice that the state has afforded the opportunity to provide this court with the supplementary heads of argument. I would appreciate it if it would be provided to the appellant prior to it being sent to court, so that the appellant would have an opportunity to also peruse it, decide whether they wish to file supplementary heads of argument in response, and then when the parties do come before this court on a next date, we will then all be better equipped and in a position to properly ventilate the matter.
As a court.
There's the court pieces.
Do you have my diary? I am not going to adjourn. I'm going to quickly send my secretary to quickly get my diary. I am looking at the week of the 1st of June. Unfortunately, I won't be able to assist you next week. I'm on the opposed role doing the urgent matters, so my role is full for that entire week. I'm contemplating either the Wednesday, the 3rd of June, or Monday, the 1st of June.
My lady, I would very much, but the 1st of June is next week, my lady. Did I not understand the context?
Next week is the week of the 20th. Today is, sorry, I'm making a mistake. I'm making a mistake. I'm still on the 18th in my brain. I'm on the 18th of May. That's why I'm looking at the week of the 25th. Yes, we're already on the 28th. Okay, so now, next week I'm busy in the opposed role. The week of the 8th to the 12th is the week that we are talking about, because then I'm on the unopposed role, giving me the days of Monday and Wednesday. Friday of that week.
My lady, my learned friend and I were contemplating the 10th of June, which is Wednesday week after next.
I'm dealing with a very big matter on that week. Can we maybe look at Friday the 12th?
My lady, I've cancelled up my diary, but if we can...
No, I don't want to put you under any... Shall we look at maybe
But may I suggest if we can agree to start maybe at 9 or 10 in the morning?
on the 12th?
Yes, please.
Yeah, no, that shouldn't be a problem.
Thanks, my lady.
If everybody's in agreement.
The 12th.
May I ask my lady that my learned friend for the state be directed to file them
The heads.
sooner? Yes, my lady, please.
So let's say if heads can be filed by the 9th,
It's in order, my lady, the 9th.
and then you file by the 10th if you need to. Then I will have the whole of Thursday to go through it. But please, let's see, if you can do it earlier, I'll be grateful.
As a copy, my lady.
Right, so this bail appeal is now being postponed to for the purposes of supplementary heads of argument to be provided by the state and then responded to by the appellant in the bail appeal. for the 12th of June 2026 for purposes of hearing.
As a court, please.
Oh, 9 o'clock in the morning on the 12th, on the
12th.
Let me just write it in my diary as well so that everybody knows. 9 o'clock in the morning on the 12th of June 2026.
Court, please.
Mr. David, I believe that's the
That
rule.
concludes all, my lady.
Right, then the court challenger.
All right.